think people have a general understanding what statute of limitations are, but they don't really know how it applies or what the number is or what it means. And if they try to handle their case, I've gotten calls, you probably have too, where they've been playing the case along and they don't really realize the statute of limitations runs out and the case is over if you don't do something about it. So, I think that's a misconception and why it's important to get to a lawyer, because the time runs out, the game is over.
Yeah, Googling statute of limitations is not a good replacement for asking a lawyer what applies to my case. And the other problem is, most of the time, by the time they've asked us that, they've done a lot of other things that may be damaging to their case that is really hard to recover from. And I think if they call on the front end, they're just a whole lot more likely to navigate all of the pitfalls that may be there, dealing with an insurance company and dealing with the statute of limitations too.
I think they also think that a statute of limitations can be told just by snapping a finger. And especially in medical malpractice cases, clients have a tendency to call. They may have a general idea about what the statute of limitations is, but they're calling right before the statute. And that's not enough time to get the case prepared and filed properly. And so they really don't understand what it means to bring a case. So Googling has pitfalls, and call early to avoid it.
Yeah, you say that. It's funny you say that, because when I meet with folks about, in particular, a medical malpractice case, I explain this is different. It's not like a car accident where if I'm on the way home today and somebody runs into the back of me, I can file a lawsuit tonight. That's not the case in a medical malpractice situation where you have to have records reviewed and have an expert that provides an affidavit. So it can spin rapidly into something they can't recover from if they wait too long.
Right. And even in a tractor trailer case, if they wait too long right before, what if you sue the wrong defendant? Or what if the defendant is deceased who is driving the vehicle? Or all these things that can really mess up a statute of limitations and sink a case. All those things can be handled earlier by calling a lawyer earlier.
Well, and by that time, so much evidence is gone as well. There's rules that require driver logs to be kept for a certain period of time. Maybe not after that period of time. There's data that you get from the electronic data recorder or the black box that you'd want to send someone out soon to get that before there's repairs made or something disappears. So it is never the wrong decision to call us first on the front end, for sure.
Right. And even the advertisers, the large, heavy advertisers are advertising for this, but it's actually true. It doesn't cost you to call us a dime, a nickel, a cent, anything. We're willing to talk. And I think the difference between a lot of firms and our firm is that a phone call goes right to the lawyer. There's no I heard you say this, and I was listening in the lobby the other day, and it's an awesome quote. There's no firewall. There's no protection between the lawyers. Obviously there's a receptionist, but if somebody calls our firm, they're going to talk to Wes, Ryan, Tom, Jeremy, Jenny, any of these people. I've missed some names. I'm not trying to keep anybody out, but the point is we're available to talk at any time, and it doesn't cost you anything, and it can save a case.
Yeah, I think it makes us a little bit different.
I feel like hiring a trial lawyer, if you hire the right one, us, we will explain to them why you're not necessarily going to a trial right out of the gate. Because I feel like people watch TV and think that if I have a case, that automatically transports me into the courtroom where I'll be on the stand and someone is going to be mean to me, which is actually not true. There's so many steps that we take along the way. And as we tell our clients, 90% of our cases in the civil arena settle before you make it to court because there's so many things that we do, like, for example, the mediation.
Yeah, everything we do is in anticipation of trying the case, because you have to do it that way to get the best recovery for the client. But statistically speaking, the percentage of cases that end up in trial are very small. And I think you're exactly right. I mean, TV makes us think that everything goes to trial, and that simply isn't the case. But it's very important that the insurance company knows that we are a firm that is not afraid to go try a case. Because frankly, you get treated differently when they know that, okay, they try cases. This is going to go to the nth degree if necessary. They're willing to spend the money and the time. But most of the time, I end up explaining that to a client that, if you're worried about that, if that's something that makes you nervous, we'll prepare you for that. But statistically speaking, it's not likely with today's climate and the mediation process that is mandatory in every case that you're going to end up having to sit in front of a jury of 12 strangers and a judge.
Right. It's like it's the do-it-yourself Home Depot theory of law, right? You don't need to do that. There are lawyers that'll talk to you about it and allay some of your fears about what might be coming down the road. Just a simple conversation can soothe a lot of those anxieties. And, we're so experienced in doing it, especially the two of us. Between the two of us are almost 60 years of legal experience. So we can answer a question within minutes and seconds and relieve stress and figure out a path forward.
When, especially in a car accident, when people are in an accident, they want to be fair. They don't want to be seen as being greedy or trying to recover something they shouldn't. And unfortunately, sometimes that leads to some mistakes. And a lot of times I'll find people and they have health insurance that will cover medical expenses from an accident, but they haven't used their health insurance. They refuse to use their health insurance, and they don't understand that the car insurance company is not going to cover your medical expenses as they're incurred. And then they get all these bills, and that they find out for the first time, well, wait a minute, Allstate, State Farm, Progressive, they're not paying these bills. I have to settle my case before I can get money, and they don't understand the reimbursement process. If they do use their health insurance, they don't understand that there may be claims that have to be paid back to the health insurance from the car insurance. It gets complicated really quickly. Wasn't always the case, but it sure is now. Even in what seems like a simple car accident, there's some complicating factors that will end up costing someone money in the end if they do not come talk to us and hire us to make sure that all those issues are handled properly, and ultimately the net to them is better than it would have been had they tried to handle this on their own with very limited information.
It's so true. And also the trick that we see where insurance companies try to get you to sign a release that says we'll pay your medical bills up to $10,000 and give you $1,000 for your pain and suffering. And what they don't really realize is that what if you need surgery and your surgery costs more than $10,000? The insurance company is not going to pay for that. So that is the classic do-it-yourself pitfall that insurance companies love. And people get intoxicated by it because they think, well, State Farm's going to pay for my medical bills. I'll be fine. But then all of a sudden, the limit runs out and the time runs out. And what about my pain and suffering? I'm only getting $2,000, but that's what they signed. It's really a pitfall, don't you think?
That happened last week, where I had someone give me a call, and they had done just that. And the insurance company had offered them $2,000, and we'll cover your medical expenses up to $10,000 until X date. And then they had an MRI done and realized they need surgery in their knee. They've already signed the release, and they've already taken money from the insurance company. And unfortunately, there's nothing we can do in that situation. That is, I see that increasingly, where insurance companies are just wanting to get something signed quickly, cap what their exposure is going to be, and that is a really unfortunate mistake. And I would advise anyone who's offered that, call a lawyer, call us before you sign anything for the insurance company releasing any claim you have. Tom, you may have this happen the first time I meet with a client. A lot of times they say to me, I'm not the lawsuit type. I'm not the suing type. And there's this misconception that I'm doing something wrong if I'm trying to be compensated fairly for something I did not cause. And I'm not sure why that's a prevalent emotion, but it really is. People feel like, well, I don't want to be seen as that guy that's trying to get over on somebody, or that guy that's trying to get something that I'm not, entitled to or deserve. The fact is, we all pay very expensive insurance premiums, and that insurance is there in the event that we need it. If you're hurt and you did nothing whatsoever to cause it, we're seeking to recover from you from the insurance company that has been paid to do just that. And we see all these commercials from these insurance companies about how they take care of everyone. And so I just wish there was. I wish folks didn't start off feeling guilty because they're the ones who are put in that position, not because something they did, but something someone else did. And that's something that happens all the time. That's where I start a conversation when someone comes in, and they say that often. And I always tell them, most folks that hire us feel the exact same way you do. They're not there because they're wanting to pursue a claim. They're there because they've been hurt. They don't know what to do. They have medical bills stacking up. They have lost wages stacking up, and they need help. And that's what we're there to do.
Mm-hmm. It's interesting. They also say, I get calls, Tom, I saw that you sent a letter to my insurance company. Why did you do that? I don't want my rates to go up. Well, we see this every day, Wes. Using your own insurance can be a requirement in the case. If it's a hit and run, we have to use your insurance because it's an uninsured case. If it's a case where the at-fault driver doesn't have enough insurance and we have to access your own insurance, which you have paid for under South Carolina law, and I want to say that again, most people in South Carolina don't realize, we know this, Wes, to have underinsurance to protect you on a case, the insured has to pay extra to get it. And so if you've got it, use it. And if you think you might have it or you don't understand, is it an uninsured case? Is it an underinsured case? Call Wes, Tom, Ryan, one of us, Toria, and take a chance and find out. You may be surprised what you realize, and it's not going to cause your rates to go up because you paid extra. It's like having life insurance on your car. You did a smart thing. You bought underinsurance, use it.
Yeah, don't be afraid to use it.